Some court hearings. Everyone is innocent until proven guilty in a court of law. The commentary and editing provided in our videos are in line with the principles of fair use, as outlined in Section 107 of the United States Copyright Law. So sit back, relax, and enjoy this video. Don't forget to smash the like button, pounce on the subscribe to get our latest content, and comment with the timestamp of your favorite moment.
Who's your client?
Your Honor, I have Austin Trahan and James Hutchins.
Did we already do these? Okay.
And I believe this is Mr. Trahan. He does qualify for PTR.
Okay. Okay, good afternoon, sir. Tell me your name, please.
Austin Trahan.
Okay, you're here today for first appearance. You do have an attorney by your side. Counsel, do you wish to be heard?
Yes, Your Honor. Blake Simons for the defendant. I have a probable cause challenge based on the definitions provided in the arrest affidavit, where the provided definition of official traffic control device, it includes signs and markings and devices. The arrest affidavit fails to specify that there is any probability that the client actually defaced the crosswalk markings by chalking the marked lines of the crosswalk, but does make specifications about markings directly on the asphalt, which doesn't constitute a traffic control device.
So it does not.
Correct.
Okay.
Further,
Do you agree that there's probable cause for criminal mischief, which is a lesser?
No, I don't, Your Honor, because no reasonable prudent person would also believe that it's probable that water-soluble chalk would cause over $1,000 in damage. FDOT's trying to fabricate a crime out of nothing. Additionally, demonstrative speech in a publicly held forum, a crosswalk is an extension of that sidewalk where free speech and demonstrative speech is one of our First Amendment rights. So I don't find that there's any probable cause for anything wrong. If we do find that, you know, we're indicating that every child or other individual creating chalk art on the street is a criminal.
The state wish to be heard?
Yes, Your Honor. And nowhere in this affidavit does it say it's water-soluble chalk. It does say chalking. It does not ever in here say that it's water-soluble or how they would get those markings up. Additionally, the sidewalk is different than a crosswalk. This crosswalk is actually in the street for an interference with official traffic control devices. A person may not alter, deface, or injure. State would argue that by chalking alters and defaces, so state would argue that there is probable cause.
Any additional argument?
FDOT's admitted to coming and washing away the chalk, and it cost them allegedly $1,000 to wash away the chalk. So they've already admitted that it's water soluble in making that accusation in and of itself.
Okay, my reading of it, I don't find criminal probable cause for a felony offense. However, I do believe it would qualify for a misdemeanor offense. What I'm inclined to do is reduce the bond to $100 and find probable cause for the criminal mischief offense based on, because I do believe that the crosswalk is a traffic control device. However, that is a defense that you can bring up at trial, I suppose, but the probable cause stage, I do believe there's sufficient probable cause at this point in time. Can he afford a bond of $100?
I would request ROR like every other instance in this matter from the previous arrests, if Your Honor would be so inclined. They have no criminal record. They have ties to the community. It's a nonviolent alleged crime.
I believe there have been 4 other, at least that I know of, 4 other similarly situated co-defendants. Probable cause found on 3 of them, no PC on 1. And the email that I have, they were ROR'd. So there have, overall have been similarities, however, some differences based on different judges, I believe. However, if Your Honor is inclined to find criminal mischief, it is state that the alleged value of the damage is $1,004, which would still make it a felony criminal mischief.
Well, I'm not going to find probable cause for felony level criminal mischief in this case. I will release you on your own recognizance, sir. That's it.
And are you finding the M2 under 200?
Yes.
And Madam Clerk, that'll be That'll be the criminal mischief under 200 M2. It's 806.13 1B1. That's B as in boy. Criminal mischief under 200, which is the M2.
Okay, ready for the next one?
Yes.
Okay, good afternoon, sir. Please tell me your name.
James Hutchins.
Okay, Mr. Hutchins, you're here today for first appearance. I do see you have an attorney by your side. Counsel, would you like to be heard again?
Blake Simons for Mr. Hutchins. Would you like me to state the same exact argument or for the record, or?
I can take record of the previous argument. I think it's the same situation, same set of facts, correct?
Exactly. the same,
Okay.
Your Honor.
Okay, well, so in that case, the court would be inclined to do the same thing. I would release you on your own recognizance and only find probable cause for the second-degree misdemeanor criminal mischief.
Madam Clerk, do you need that statute again?
Okay, thank you, sir.
That's all I have today, Your Honor. May I be excused?
Yes.
We would ask to waive that appearance, Your Honor.
We have Brutus next.
Okay, and there was Carson. So I do, the probable cause was found by warrant. His bond is set at $2,500. Did you want to be heard on bond? I'm sorry, what did I, yeah, I said 2,500.
This one?
Carson, I don't know why it's so high.
Are you asking me, Your Honor?
I don't have the facts. I was asking you if you wanted me to consider reducing the bond. Because it's a misdemeanor petty theft, correct?
Yes, it is, Your Honor. Yes, I would like you to reduce the bond, Your Honor.
Okay, I'll reduce his bond to $500 unless the state wanted to put anything on the record.
And Your Honor, this was
If there was a potentially egregious nature of,
it was a repeat offender at Target. They know him well. There was about $81 worth of merchandise allegedly stolen.
okay, I'm gonna reduce the bond to $500. He does have an out-on-bond purchase of cocaine case.
I would like to be heard briefly on that one, Your Honor.
So was he on pretrial release, or it just says NA for bond?
I believe,
ROR.
yes,
Okay,
He was released on probable cause.
yes, he was ROR'd, I believe, November 4th, Your Honor. That case stems back to September 21st. It hasn't been filed on, Your Honor. We ask that you just take no action.
it was from when?
So, it stems back to September 21st. It hasn't been filed on, Your Honor. We just ask that you take no action.
And Your Honor, he was just released. He had bond. He was released on a 33-day motion, which is why he was ROR'd. He was not originally ROR'd, but he was just ROR'd, it looks like, on 11/4.
That's what I have.
So
11.
he was out for 2 to 3 weeks before allegedly picking up the new petty theft. So state is requesting that you revoke and you reinstate the bond that was originally put in order.
Okay, I'm gonna take no action at this point in time.
Thank you, Your Honor.
Good afternoon, tell me your name, please.
On Brutus.
Okay, Mr. Brutus, you're here today for arraignment. You have 2 cases. Do you want the public defender
Yes, ma'am.
to represent you? Okay. The first case is leaving the scene of an accident without giving information. I'll appoint the public defender and enter a plea of not guilty for you on that case. And then your other case is reckless driving. I'll appoint the public defender on that case, enter a plea of not guilty.
Both cases will be heard in Division 62. Pretrial conference is December the 11th at 1:30, courtroom 12C.
Okay.
Thank you, Your Honor.
All right, good afternoon. Tell me your name, please.
Bonitoz.
All right, sir, you're here today for arraignment. You're charged with battery. I will appoint the public defender to represent you. And will enter a plea of not guilty.
Case will be heard in Division 63. Pretrial conference is December the 18th at 9 a.m., courtroom 6C.
Okay.
I just need a moment, Your Honor. I just want to make sure there wasn't an offer conveyed to me for Mr.
There was not.
Okay, that's all. That's just not today.
Is that it?
Yep.
Okay. Thank you.
All right, good afternoon. Tell me your name.
My name is James Gary Jones.
There was an offer.
James Gary Jones.
Okay, Mr. Jones. You're here today for arraignment. However, it appears there might be a plea offer. Are you interested in resolving the case today?
Yes, ma'am.
Okay.
The offer that was conveyed to Mr. Jones was an adjudication of guilt, credit for time served, and there's cost investigation to OPD in the amount of $107.13. Yes, ma'am.
May I approach, Your Honor?
Yes. Okay, can you raise your right hand to be sworn in, sir?
Do you solemnly swear affirm the testimony you give today is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, sir, so your attorney has advised me that you wish to change your plea from not guilty to no contest to the charge of resisting an officer without violence. Is that what you want to do today?
Yes, ma'am.
Okay, and I was handed a plea form with your name at the top. Is this your signature at the bottom? Okay. Did you have enough time to discuss this case with the public defender's office? Okay, so you understand you'd be waiving your right to go to trial today, and you want to give up that right?
Yes, ma'am.
Okay. Has anyone forced, threatened, or coerced you into signing this plea agreement?
No.
All right. I'll find that you are alert and intelligent and represented by counsel. I'll accept your plea of no contest as charged. I'll sentence you to credit for time served. I have that you have 39 days time served. You'll also have to pay a court costs and a cost of investigation. Are you going to be working when you get out?
Yes, I get an SSI check. I pay.
You sure? Okay, I'll give you 18 months to pay your court costs. There's also a cost of investigation, if I didn't say it already, $107.13. Okay, so I'm giving you a year and a half to pay. If you need additional time, you could set up a payment plan with the clerk of court. Okay? All right, you do have 30 days to appeal the judgment and sentence. If you want to appeal, it must be in writing, and you have the right to an attorney. If you can't afford one, one will be appointed for you for the appeal, okay? All right, good luck to you, sir. Okay, you too.
Your Honor, James Jones, Neville's refused. Linda Neville's refused.
We would just ask to plead no contest, no, not guilty.
Which one was that?
Linda Neville's.
Okay, you're going to waive her arraignment, enter a plea of not guilty?
Yes, Your Honor.
Okay. All right, on Linda Neville's, that will be set for pretrial conference?
Pretrial conference, Division 63.
I apologize, Your Honor. Is there any chance we could maybe, she has an offer, is there any chance we could reset her tomorrow?
What was she, a refusal? Your Honor, if she refused, we just asked her to be set for PTC, and she can accept the offer at PTC.
No, yeah. But there's no issue with that by defense, Your Honor.
Okay.
Yep, that's
All right. When's her pretrial conference?
Division 63, December the 18th at 9 a.m., courtroom 6C.
Okay, perhaps the PD can get out there sooner and talk to her and see if she wants to set it, because that's... all right. Oh, good afternoon. Tell me your name, please.
William Demetrius Tynes.
Okay, Mr. Tynes, you're here today for arraignment.
Your Honor, Mr. Tynes had an offer conveyed to him. It was an adjudication, credit time served, cost of investigation. I was just asked by Mr. Tynes if the court, I know this is the state's offer, but if the court would also consider potentially making this a withhold. I understand the state may have opposition to it, but my client had asked me to ask the court.
Why does he want the withhold?
He would like to preserve his record, Your Honor. A withhold. So this is just a regular,
He doesn't have any prior adjudications?
I don't know, Your Honor. I'm asking on behalf of my client.
I don't have a problem with the withhold over the state's objection.
And Your Honor, Mr. Tynes has extensive criminal history. He currently has, I believe, an open cocaine, an open agbat, previous withholds, he's a convicted felon. He has a adjudication on a possession of a controlled substance out of Orange. Another convicted felon case, 2008, an altered banknote. He was adjudicated guilty out of Pasco. Adjudicated in 2006 on a sale and delivery of cocaine out of Duval. Adjudicated guilty out of Orange for another possession of controlled substance. Adjudicated in 03 out of Orange for controlled substance. 03, controlled substance. Adjudicated of a resisting. No valid, another resisting, another controlled substance.
Mr. Tynes, I don't know how much a withhold is going to matter in this case. It might change the court costs very, very slightly, but being that you have significant history, I would not be inclined to withhold. Is that okay? Do you still want to go forward?
Yes, ma'am.
Okay. Yes. Can you raise your right hand to be sworn in?
Yes, ma'am.
Do you solemnly swear affirm the testimony you give today is the truth, whole truth, and nothing but the truth?
Yes, ma'am.
Okay, sir. So your attorney has handed me a plea form with your name at the top. Is this your signature at the bottom?
Yes, ma'am.
Okay. So it's my understanding you wish to plead no contest to this charge?
Yes, ma'am.
Okay. Has anyone forced, threatened, or coerced you into entering into this plea agreement?
No, ma'am.
Okay. And you're thinking clearly today?
Yes, ma'am.
All right. I'll find that you are alert and intelligent and represented by counsel. I'll accept your plea of no contest as charged. I'll adjudicate you guilty and sentence you to credit for time served. You have 45 days time served. What was the cost of investigation?
$116 to OPD.
$116 cost of investigation to Orlando Police Department. You'll also have some court costs and cost of prosecution. Are you going to be working?
No, ma'am, not at the moment. I'm gonna get a job, though.
Okay, I'll give you 18 months to pay your court costs, cost prosecution, and everything. If you need additional time, you could set up a payment plan with the clerk of court, okay?
Yes, ma'am.
You have 30 days to appeal the judgment and sentence. If you want to appeal, it must be in writing and filed within 30 days of today. All right, good luck to you, sir.
Thank you.
All right, good afternoon. Tell me your name, please.
Your Honor, there is an offer conveyed to my client. It was an adjudication, credit time served, no return to the 7-Eleven, 41715 South Goldenrod Road, Orlando, Florida. Cost of investigation, $326.64 to
And that would be to OPD, Your Honor.
Okay. Okay, can you raise your right hand and be sworn in?
Do you solemnly swear affirm the testimony you give today is the truth, whole truth, and nothing but the truth?
Yes.
All right, thank you. So your attorney has advised me you wish to change your plea from not guilty to no contest to the charge of resisting an officer without violence. Is that what you want to do today?
no.
Okay, you got to speak up just a little bit, okay? I was handed a plea form with your name at the top. Is this your signature at the bottom? Okay, so are you're understanding correctly that you'd be waiving your constitutional right to go to trial in this case? Yes. All right. Has anyone forced, threatened, or coerced you into entering into this plea agreement?
No, ma'am.
All right, and you're thinking clearly today?
Yes.
Okay. I'll find that you are alert and intelligent and represented by counsel. I'll accept your plea of no contest as charged. I will adjudicate you guilty and sentence you to 16 days credit time served. You're not to return to the 7-Eleven where this occurred on Goldenrod Road. There's a cost of investigation of $326.64 to Orlando Police Department. Are you going to be working?
I'm gonna have to find a job.
Okay, I'll give you 18 months to pay the court costs and everything. If you need additional time, you could set up a payment plan with the clerk of court. Okay, you have 30 days to appeal the judgment and sentence. If you want to appeal, it has to be in writing. And you have the right to an attorney if you can't afford one. One will be appointed for you, okay? All right, good luck to you. All right, good afternoon. Tell me your name, please.
Mr. Tyrese Bernard.
All right, Mr. Bernard. Okay, you're here today for your first appearance. You were arrested for possession of a prescription without, possession of a drug without a prescription. Your bond is currently set at $500. I do find probable cause for that offense, and I'll appoint the public defender to represent you. You also have, is there any, an open container case? Is there an offer in these cases or no?
There's not, Your Honor, just because it will limit his defenses if he pleads to that open container on the other case.
All right. On the open container case, your bond is set at $250. I do find probable cause, and I'll appoint the public defender to represent you.
Your Honor, for the prescription drug without a script charge, what was the bond amount for that?
500?
Thank you, Your Honor.
Okay, sir, if I did just stay in contact with the public defender, okay? All right, good afternoon. Tell me your name, please.
Jordan Carter.
All right, Mr. Carter, you're here today for first appearance. You're charged with trespass. I do find probable cause, and I'll appoint the public defender to represent you. Can you afford to bond out?
Can I afford to button out?
Yeah. Not at the moment? Do you have a way to stay in contact with the public defender's office?
Yes, ma'am, I do.
Okay. I'm going to release you on your own recognizance, but you cannot return to the address where this occurred, okay? It's 8700 South Orange Blossom Trail, and I need you to contact the public defender's office within 2 weeks of your release, because we don't have a court date for you right now, but you'll probably get one later on.
Okay.
And if you fail to appear for that court date, you're going to get another KPS and end up back in jail. Hold on one second. Hold on. We're going to give you an arraignment date.
December 18th.
Okay, December 18th for arraignment. It's going to be in 4C, right? In courtroom 4C at the downtown courtroom, okay? You need to appear for that or else you're going to get a KPS.
I want to appear.
Okay.
Thank you very much, Your Honor. No, this is your form now. Okay. Yeah, use that to reach out.
Your Honor, Otis Dennis is mental health.
We'd ask to waive that appearance, Your Honor.
Okay.
Oh, I apologize. I believe Mr. Dennis actually has an offer.
He does not.
He does not? Okay, then we'd ask to waive.
Okay. On Otis Dennis, I do find probable cause for the charge of battery, and bond will be stayed at $1,000. No contact with the victim, no weapons or firearms. Good afternoon. Tell me your name, please.
Good afternoon. My name is Zara Dow.
Okay, Ms. Dow, you're here today for first appearance.
Yes, ma'am.
All right, you have 2 charges of petty theft that you were arrested for. I do find probable cause, and I'll appoint the public defender to represent you. Your bond is currently set at $1,000. I'm going to reduce that to $500 on each count. You need to stay in contact with the public defender's office and do not return to the scene, okay? You are also out on bond on a charge of battery domestic violence. Since those cases are unrelated, I'm not going to take action on that case.
Yes, ma'am.
But you need to stay out of trouble because you're just going to keep ending up back here, okay?
Yes, ma'am, I will not, thank you.
Five, each count. The scene.
Yes. Okay, good afternoon. Tell me your name, please.
Nicole Duran.
All right, Ms. Duran, you're here today for your first appearance. You were arrested on a charge of battery. I do find probable cause for that charge. State wish to be heard on bond.
Yes, Your Honor. Understanding that it is higher than normal, I believe largely that's due to the aggravating factor that there were 3 victims, one of which was a 1-year-old child that was in one of the victims' hands. It is alleged that one of the victims was holding the 1-year-old child who got punched in the face twice and his arm pulled by the defendant. So due to there being those 3 victims and the 1-year-old child present, they would argue that the bond is reasonable. Also take into account her last conviction is for a battery about 3 months ago.
Are you asking for any additional terms?
Just standard conditions of no contact, no return, no weapons.
Okay, ma'am. I do find probable cause for the battery. I appoint the public defender to represent you. I'm going to leave your bond at $3,000 with the conditions that you're not to have contact with any of the 3 victims. And you know what no contact means, right? So no in-person contact, no electronic, no third-party contact, okay?
Yes, ma'am.
Make sure you stay in contact with the public defender's office if you do bond out.
Okay.
You're not to possess any weapons or firearms. All right, that's it.
Your Honor, Jeremy Green behavior.
We'd ask to waive that appearance, Your Honor. Or, give me 1 second, Your Honor. Yes, we'd ask to reset Mr. Green. Actually, he does have an offer.
Let me reset it for a Friday. Just kidding. Okay, does the state have objection to me resetting?
No, Your Honor, you would potentially be able to do PCI downtown, but no objection to the reset. The offer was a withhold on credit.
Okay, for right now, his bond is set at $2,000 on each count. We could reset it to tomorrow.
Yeah, okay. Thank you, Your Honor.
Your Honor, William Ortiz bonded.
All right. Simmons?
We'd ask to waive that appearance, Your Honor.
Okay, on Mr. Simmons, I do find probable cause. I'll appoint the public defender, and his bond will be stayed at $500.
Other conditions, Your Honor?
No contact with the victim, no return to the scene, no weapons, no firearms.
Thank you.
Yeah. Okay, good afternoon. Tell me your name, please.
Witter Savannah.
All right, you're here today for first appearance. You're arrested for trespass and resisting an officer without violence.
Your Honor, I had called Miss Witter's name back in the jail, Your Honor, but I was unable to get her to acknowledge me, or I think she may have just been busy, but she does have an offer. I don't know if you would mind me conveying it. I have pled Ms. Witter in the past. I believe she is informed about the plea process, but I just think she deserves to know what the offer is. But I understand if you believe it's not enough time. It's up to you, Your Honor.
Well, state conveyed an offer. She has to know what the offer conveyed was. The offer conveyed was an adjudication, 5 days, credit for 2, and no return.
Can I have counsel approach?
Yep.
Okay, oh, hold on real quick. So there's been a plea offer made. I'm going to give you some time to talk to your attorney, but I don't want you to feel pressured. If you need additional time, I can bring you back another day. Do you want to talk to your attorney right now about the offer, or would you prefer to come back a different day?
I'll come back a different day.
Okay. All right, so in that case, we're going to just do your initial appearance. So I do find probable cause for those 2 charges. Your bonds will be stayed at $500 on each count. And if I didn't say it already, I'll appoint the public defender to represent you, okay?
Okay.
All right. If you do bond out, you're not to return to the location. Are you aware of the location without me telling you right now?
Can you repeat what you're telling me? I'm not even understanding you.
Okay, I understand. So you have 2 charges. You're charged with trespass and resisting an officer without violence, okay? Today, your purpose of being here is for first appearance, and it's for me to tell you what those charges are and to set bond. So your bond is currently going to be stayed at $500 for each of those counts. So if you wanted to bond out, you would have to either pay $500 per count or get a bondsman, okay? The state has made a plea offer to resolve the case and those 2 charges. And I didn't want you to feel pressured, so I was going to give you some more time to think about the plea offer.
I'll take more time.
Okay, all right. Thank you.
Your Honor, Gregory Carson refused.
We already did him. We already addressed him.
Gregory Carson? Is that-
We addressed him already.
That's what I thought,
He was
yeah.
on a move up, yeah.
Okay, good afternoon. Tell me your name, please.
Robert Bauer.
All right, so you're here today for first appearance. You were arrested for an open container violation. Is this one that can be resolved?
No, Your Honor, he's on probation.
Okay. All right, sir, you do have a bond of $250 on that charge. So your bond will be, what?
Sorry, I do 1 point PD.
Okay, I'll appoint the public defender to represent you, okay?
And he does have reporting requirements.
If you do bond out, make sure you comply with your reporting requirements of probation, okay? All right. All right, good afternoon. Tell me your name, please.
Campos. Raekwon Campos.
Okay, you're here today for first appearance. You were arrested for disorderly conduct. I do find probable cause, and I'll appoint the public defender to represent you.
We just asked that you set a bond, Your Honor. It's a fighting disorderly.
Okay, well, his bond was at $250. Can you afford to bond out?
I don't have a job right now, but I could try to make something happen. Like something, I have to make a call.
Okay, I'll reduce your bond to $50. If you do bond out, you need to stay in contact with the public defender's office, okay?
And your Honor, state's only request would be a no return back to 19 East Central Boulevard,
Is that a business?
business downtown where they were allegedly fighting outside of.
Okay, sir. So if you do bond out, you're not to return to the location where this allegedly occurred. It's 19 East Central. Okay? All right. Okay, you too. Good afternoon. Tell me your name, please.
Stafford Hamilton.
Your Honor, there was an offer conveyed to Mr. Hamilton.
How you say his first name?
Do you have a booking-
Gensley Charles?
You have a booking number?
You want-
It would start with 2503.
2503-7238.
They bonded out.
So now, who you got next, Judge?
Hamilton. Okay, Mr. Hamilton, can you raise your right hand to be sworn in?
Do you solemnly
Yes,
swear
ma'am.
affirm the testimony you give today is the truth, whole truth, and nothing but the truth?
Yes, ma'am.
Sir. Okay, I've been handed a plea form with your name at the top. Is this your signature at the bottom?
Yes, ma'am.
Okay, so this tells me that you want to take a plea of no contest today to the charge of open container violation.
Yes, ma'am.
Okay, and you're thinking clearly today?
Yes, ma'am.
All right, and by signing this plea form, you're acknowledging that you read over this and you're aware that you're giving up some constitutional rights today, such as your right to go to trial in this case. Is that your understanding?
Yes, ma'am.
Okay, has anyone forced, threatened, or coerced you into entering into this plea agreement?
No, ma'am.
Okay, I'll find that you are alert and intelligent and represented by counsel. I'll accept your plea of no contest as charged. What was the agreement?
It was an adjudication, 2 days credit.
All right, I'll adjudicate you guilty and sentence you to 2 days with credit for 2 days' time served, okay? So you'll be released as to this charge. You do have the right to appeal the judgment and sentence imposed upon you today. If you want to appeal, it must be in writing, and you have the right to an attorney. If you can't afford one, one will be appointed for you for the appeal, okay?
Yes, ma'am.
All right, good luck to you, sir.
All right, thank you.
Oh, I'm sorry, you have some court costs and costs of prosecution. I'll reduce those to a civil judgment, okay?
Yes, ma'am.
I had to tap out of order. Oh, really? Yeah, I had to, because it's a civil judgment. I had to send it to recording. So, I have to change the judge's name. Oh, well. That's why we give it to you. Let's see. Go, I mean, you keep going.
Harrison?
Harrison bonded, Your Honor.
Okay.
Okay, that's what they'll find it.
Jones?
Also bonded, Your Honor.
Good afternoon, tell me your name, please. All right, sir, you're here today for initial appearance.
There was an offer
Okay.
conveyed to my client, Your Honor. It was an adjudication, credit time served offer.
Sir, can you raise your right hand to be sworn in?
You solemnly swear affirm the testimony you give today is the truth, whole truth, and nothing but the truth?
Yes, ma'am.
Okay, thank you, sir. Your attorney has informed me that you wish to change your plea from not guilty and change that to a plea of no contest to the open container violation. Is that what you want to do today?
Yes, ma'am.
Okay, and I was handed a plea form with your name at the top. Is this your signature at the bottom?
Yes.
So you had enough time to go over this plea form and understand that you'd be giving up some constitutional rights today, such as your right to go to trial?
Yes.
Okay, and you're thinking clearly today?
Yes, ma'am.
No one has forced, threatened, or coerced you into entering into this plea form?
No.
All right. I'll find that you are alert and intelligent and represented by counsel. I'll accept your plea of no contest as charged. I'll adjudicate you guilty and sentence you to credit for time served.
Yes, 2 days.
You have 2 days' time served, okay? You're going to have some court costs and costs of prosecution. Are you going to be working?
Yes.
Okay. Do you need more than a year to pay?
Yeah, be fine.
Okay, I'll give you a year to pay your court costs. You have 30 days to appeal the judgment and sentence in this case. The appeal must be in writing, and you have the right to an attorney if you can't afford one. One will be appointed for you for appeal, okay?
Ma'am.
So you'll be released as to this charge. Thank you. McCain?
McCain,
McCann?
RR, your honor. RR.
RR?
Yes, ma'am.
Oh, he's gone. He already-
Your Honor, McKinnon, McMillan, surety bond. Your Honor, Mitchell, Casman Mitchell, bonded.
All right, good afternoon. Tell me your name, please.
My name is Otis Williams.
Okay, Mr. Williams, you're here today for first appearance. You're charged with state misdemeanors, which is apparently a resisting without violence. I do find probable cause for that offense. I'll appoint the public defender to represent you. You also have an open container violation.
And there was an offer conveyed concurrent on both of Mr. Williams' cases of an adjudication of guilt and credit for 2 days.
Okay. Is that what you want to do?
Yes.
Okay, can you raise your right hand to be sworn in?
You solemnly swear affirm the testimony you give today is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, sir, so I've been handed a plea form with your name at the top. Is this your signature at the bottom?
Yes.
And by signing this form, you're acknowledging that you're waiving some constitutional rights today, like your right to go to trial in these cases? Is that your understanding?
Yes.
Okay, is he playing to both cases?
Yes, Your Honor, they should be running concurrently.
Okay, I gotta write the other one on here.
Oh,
I just want to make sure that's the understanding.
yes, Your Honor.
Okay. Okay, so I added the second case to the top, but you understand that you're pleading to those two separate cases?
Yes.
Okay, it might have all happened in the same day, but the police put it on two separate cases. Okay. All right, and you understand you'd be waiving your right to go to trial on both of those charges?
Yes, ma'am.
Okay. Has anyone forced, threatened, or coerced you into entering into the plea agreement?
No, ma'am.
All right, and you're thinking clearly today?
Yes, ma'am.
Okay, I'll find that you are alert and intelligent and represented by counsel. I'll accept your plea of no contest to both of those charges, and I will adjudicate you guilty and sentence you to 2 days credit time served, concurrent on both cases. You're going to have some court costs and costs of prosecution. Are you going to be working?
I should be in about a month, please.
Okay, I'll give you 18 months to pay the court costs and costs of prosecution, okay?
Okay.
On both those cases. You do have the right to appeal the judgment and sentences. If you want to appeal, it has to be in writing, and you have the right to an attorney. If you can't afford one will be appointed for you for the appeal, okay?
Okay.
So you'll be released as to these two cases. Good luck to you.
Okay, thank you.
No, you're all set, sir.
All right, good afternoon. Tell me your name, please.
Amanda Ali.
Okay, you're here today for initial appearance. You're charged with operating a motor vehicle without a valid license. I do find probable cause, and I'll appoint the public defender to represent you. Your bond is set at $500.
The next defendant qualifies for PTR.
Okay, good afternoon. Tell me your name, please.
Vincent Calabrese.
All right, Mr. Calabrese, you're here today for first appearance for a DUI case. Okay, I do find probable cause for the charge. I'll appoint the public defender to be your attorney. Did you want to be released on pretrial release?
Do you remember talking?
Okay, so you'll be released on pretrial release, so you'll need to stay in contact with your pretrial release officer and also your public defender, okay?
Any special conditions with it, Your Honor?
It's a DUI case.
I have to ask.
Okay. All right, no special
I
conditions.
just have to ask.
Thank you, Your Honor. Yeah, sorry. I should do one of these. There you go. Oh, yeah.
Hey, good afternoon. Tell me your name, please.
Almost cheat him, ma'am.
I remember. Your Honor, there was an offer conveyed to Mr. Cheatham.
The offer conveyed was an adjudication of guilt and credit for time served for the underlying no valid.
Now, I had spoken to Mr. Cheatham. I believe what he tells me, does he, pretrial services, does he have any other open cases?
He has a hold out of Polk County, so if he does plea here, he should just know he'll be transported over to Polk. He has a no bond hold in Polk.
No bond hold there?
Mm-hmm.
Your Honor, can I just please, I need a moment for him. Can we reset him to the end of today? Just briefly. You sure? Okay.
Are you able to get a driver's license if you get out?
Yes, ma'am.
Because if you're able to, you could possibly get this case dismissed later on if you get a valid driver's license. But I understand you'd have to take care of your Polk County case.
But I have to have an address to have 2 forms of letters to show DMV that I have residence, because I don't have a residence. I've been staying in hotels.
Okay, well, you have a bond of $500 in this case.
Can you make?
Can I take care of this case today then?
Yeah, I've told my client that he could pay a bond and get his license like he plans to, but he seems adamant that you.
Yes, so I can go to Polk County, because that's.
Okay, so you can't pay the bond? Is
I have to.
okay. All right, Your Honor. No worries. You would like to go forward with the offer, Your Honor?
Okay. All right, sir, can you raise your right hand to be sworn in?
Do you solemnly swear affirm the testimony you give today is the truth, the whole truth, and nothing but the truth? I was trying to get his attention for fingerprints. Come back. Raise your right hand. I'm sorry. Do you solemnly swear affirm the testimony you give today is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Yeah, I need fingerprints. Yeah. Yeah.
All right, sir, your attorney has advised me you wanted to plead no contest to this driving without a valid license case. Is that what you want to do?
Yes, to get it away today, ma'am.
Well, are you sure you're not feeling pressured or coerced?
No, I just want all this stuff passed.
Okay. Are you aware that this is an enhanceable offense? Meaning if you do this again, you could possibly get an enhanced sentence, such as jail time.
I told you it's enhanceable back there. Your Honor, I feel I've gone through it with my client. I just don't think he understands all the ramifications with this plea. Every time I try to present the bond, I would feel more comfortable applying a bond, setting a bond. I don't feel comfortable that my client.
Okay, well, here's the situation. So you have a $500 bond, okay? I'm confident that if you speak to your public defender that's assigned to this case, they could possibly, you know, get you I can't lower your bond today because it was set by the trial judge, but they could possibly do something about your bond, and then you could help, they could help you with your situation, okay? So I'm not gonna take a plea from you today. I'll leave the bond at $500. I'll appoint the public defender if they have not been appointed for you, okay? And then when you're more informed, you can attempt to resolve. You're not gonna lose the plea offer, okay?
Okay, thank you, Your Honor. I didn't know.
All right.
It's fine. I'm trying to look out for you.
Gonzalez, Martin Gonzalez refused.
We'd have to
Silva?
waive it.
We have De Silva first.
Okay, tell me your name, please.
Luis Fernando Silva.
All right, you're here today for you're here today for first appearance on a driving offense for driving with a license that was expired more than 6 months.
Yes, ma'am.
Does he have any holds?
Not at this time, Your Honor.
Okay, are you able to bond out?
The judge is asking.
Can you afford to bond out?
Yeah, but I don't have a number, nobody. All I have in the house, I can go to my car, but I my wallet.
Can't hear.
He wouldn't have anyone to sign for him if he were to bond out. He doesn't have anyone to reach out to. That's his issue. He has the money, but he doesn't have.
Okay, I'll reduce your bond to $100. If you get out, you can't drive unless you have a valid license, okay? And make sure to stay in contact with the public defenders. I do find probable cause, I'll appoint the public defender.
You just reach out. They'll give you an attorney. No problem.
Thank you, sir.
Gonzalez?
Yeah, that's the one that refused, Your Honor. Martin Gonzalez.
We would ask to waive that appearance, Your Honor.
Okay, on Gonzalez, I do find probable cause for driving with the suspended license. His bond will be stayed at $500. He was out on bond for a DUI case, I think, yes. Right? Is that correct? He was out on bond for a DUI?
Yes, Your Honor. It's from back in July, I believe.
It was in July?
I believe it's from July, yes.
Okay, I'll appoint the public defender on the new case.
And that DUI is still open and pending. It is filed by citation. He has PTC in front of Judge Skipper on 12/10. Given that it was also a driving offense, state's requesting that you revoke.
We would ask that you consider revoking and doubling, Your Honor.
Okay, I'm going to revoke the $1,000 bond. I'll set a new bond of $2,000. All right. Gonzalez? No. Gregory?
Do you have a booking number for Gregory? Oh.
Oh, it's Harding, sorry.
Oh, Harding, okay.
Good afternoon. Tell me your name, please.
Greg Harding.
Okay, Mr. Harding, you're here today for first appearance.
Your Honor, there was an offer conveyed to Mr. Harding. It was an adjudication of guilt, credit time served.
All All right, sir, will you please raise your right hand to be sworn in?
You solemnly swear affirm the testimony you give today is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, sir, your attorney has advised me that you want to plead no contest today to the charge of driving while license suspended, a second or subsequent offense. Is that what you want to do today?
Yes, ma'am.
Okay, and you're aware that if you keep driving or getting caught with driving with a suspended license, it could be an enhanced offense, meaning you could get a greater punishment if this happens again?
Yes, ma'am.
All right. I was handed a plea form with your name at the top. Is this your signature at the bottom?
Yes, ma'am.
Okay, and by signing this, you're acknowledging that you read and understood the rights you'd be giving up today, such as your right to go to trial. Is that your understanding?
That's correct.
And you're thinking clearly today?
Yes, ma'am.
Has anyone forced, threatened, or coerced you into pleading no contest to this?
No, ma'am.
All right, I'll accept your plea of no contest. I'll find that you're alert and intelligent and represented by counsel. I will adjudicate you guilty and sentence you to credit for time served.
Is it 2 days, Taylor?
It's 2 days.
You have 2 days' time served. You do have, you'll have to pay court costs, cost prosecution. I'll give you 1 year to pay that, your court costs and everything. You do have the right to appeal the judgment and sentence in this case. The appeal must be in writing and filed within 30 days of today. Okay? All right, good luck to you.
We got Prince on Harding, right? Thank you.
Devontae Heflin? Okay. Cameron Palmer?
Bond, Your Honor.
This one says Johnson. I don't have Palmer.
Johnson bonded? Okay.
Yes.
So Johnson bonded.
I don't have,
She bonded.
oh.
Carlos Salas. Bonded as well.
Palmer? Bonded, okay.
Yes, bonded.
Salas?
Also bonded.
Sarah Turner? Okay. Tell me your name one more time.
Sarah Turner.
Okay, good afternoon. You're here today for first appearance. You were arrested for a charge of driving while under the influence. I do find probable cause, and I'll appoint the public defender to represent you. Your bond will be stayed at $1,000. If you do bond out, make sure you don't drive if your license is suspended. I also appointed the public defender to represent you, so make sure you stay in contact with them. Okay? Christian, tell me your name, please.
Vasquez Nieves.
Okay, sir, you're here today for first appearance. You're charged with operating a vehicle without a valid license and operating a motorcycle without a valid license. I do find probable cause for those charges. So is it driving and then he didn't have the motorcycle endorsement? Is that why there's two?
Yes, Your Honor, I believe so. He's out
Okay.
on bond for the same thing.
What's that?
He's also out on bond for the same thing.
All right, you were also out on bond for operating a motor vehicle without a valid license and no motor vehicle registration.
And, before you make a decision on that out on bond, Your Honor, I'd just like to be heard on it.
Okay?
Your Honor, I understand. It is effective. It's the same charge. But I would like to point out that in my client's history, he's never failed to appear. I think in this case, taking no action would be obviously the incorrect ask. I think some action needs to be taken on your part, Your Honor, considering the similarity of the charges. We'd ask that you revoke it and double it, and just allow him to continue to work. He works in the area. He's lived here his whole life, Your Honor. If you make the bond more expensive, I think he'll be incentivized to show up to court like his history suggests he has, and to not pick up any further charges going forward.
All right, sir, I understand it's really tough to get around Orlando or Central Florida without a car or a license, but you know, you can't do that, okay? You're just gonna keep getting arrested.
The state's only concern is he stated his employer is a towing company. I don't know what he does at the towing company.
Well, I suppose that's between him, you can't drive without a license, okay?
He represents to me, he's a dispatcher. From his representations, it's not a position that requires him to drive.
All right, so on the, what is the case number? I'll leave the two bonds, I do find probable cause for the two new charges. I'll leave the bond set at $500 on each case. On the 2025 CT 407610, I'm going to revoke the $500 bond, set a new bond of $1,000.
I think that's the case number for the new law.
Oh, okay,
The out
gotcha.
on bond is
Sorry.
406498 and the 406497.
Okay, so the 406498 case, the bond will be revoked, and I'll set a new bond of $1,000. I'm just going to leave the other bond in place. I just don't see what other purpose it's going to serve.
9497 is no action.
Correct, so no action on the other case. All right, next. Good afternoon, tell me your name, please. Taylor Winslow. All right, you're here today for first appearance. You're charged with driving while license suspended or revoked. I do find probable cause. And I'll leave your bond at $500 on that case, and I'll appoint the public defender to represent you. Does state wish to be heard on her out on bond case?
Your Honor, given that it is the exact same charge, state's requesting that you revoke. Is it out of Orange?
It is, I could not find a case number anywhere. I don't think one has been assigned.
That's what I'm.
But, I mean, from past booking, she was here on it.
It was what?
She was here on it, but we couldn't find a case number assigned to it. But, I mean, she was here and was released on cash bond, but I don't see any case number in the clerk or the state. It was a Dwillis. It's from 10/22/25.
She's on the correction law. It's missing something.
Okay.
We had to put on correction law. We had to wait for the officer.
Okay. Yeah.
Your Honor, with that additional information, the state's still requesting that you revoke that out on bond. It's been exactly a month before she picked up the same charge again.
Your Honor, I understand that concern, Your Honor. My client has basically no history, Your Honor. She lives in the area. She's paid a bond on it, Your Honor. We would just ask that you take no action. I don't think this is, these two charges are indicative of my client. I think that she's just in some circumstances in her life that have her in this position. I think she can get her license back, and I think going forward she'll go to court and she won't pick up any more charges. We ask for a second chance, Your Honor.
I know it's tough to get around Orlando if you don't have a license, but you cannot drive without a license. There's reasons why people get their license suspended. The fact that it happened just a month ago, I'm going to revoke the prior bond, but I will set a new bond of $500, which is double what her original bond was, because it was, the info I have says it was $250. Okay? Please make it a priority to get your license fixed.
Thank you.
All right. Good afternoon. Tell me your name, please.
My name is Patricia Allen.
All right, Ms. Allen, you're here today for first appearance. You were arrested for attempted tampering with physical evidence, possession of cannabis, and possession of drug paraphernalia. I do find probable cause for those offenses. On count one, I'm going to set your bond at $1,000. On count two, I'm going to stay your bond at $500. And on count three, I'll stay your bond at $500. Please stay in contact with your public defender.
What were the two bond amounts of my client? It was 1,000 for the.
1,000 on count one, and so I'm setting it at 1,000 on count one and staying the bond at 500 on count two and 500 on count three. So it's 2,000 total.
My client would like the court to know that she has a valid medical marijuana card. I don't know if it'll have any influence on the court's decision or with bond. I just feel like I feel it may be relevant.
And Your Honor, at this point, Sue would argue that it's not relevant to have the cannabis with her medical marijuana card. She had to have it particularly packaged. It was not in this case, nor was it presented to law enforcement. So I don't believe it changes any of the bonds or conditions. And count one has already been significantly reduced. The schedule's 25, and Your Honor set it at 1,000. So they would ask.
I already gave you a break on the bond. Like it should be said, like, as the state said, it's the standard bond or the bond schedule is 2,500. I brought it down to 1,000. So I understand what you're saying, but today's just probable cause determination. You can, I think I can't give you legal advice, but it could affect your case later on down the line. But today's just probable cause and bond. Okay. All right. Good luck to you.
Oh, you're getting us, ma'am. Okay.
All right. Good afternoon. Tell me your name, please.
Marcus Bailey, Devon, and Gomez. Good morning, Judge.
Good afternoon, sir. How are you?
All right.
You're here today for initial appearance. You're charged with driving without the motor vehicle registration and driving with your license revoked as a habitual offender. I've reviewed the charging affidavit, and I do find probable cause for those offenses. I will appoint the public defender to represent you. Your bonds will be stayed at $500 on count one and $2,500 on count two. If you do bond out, make sure you stay in contact with the public defender's office.
And I need to be able to get back. Yeah, I got bugged. They wouldn't let me bond out last night due to the fact that I don't live here. So the bondsman want to take my money. I can't do the bond. husband won't allow me to bond out because I'm not from Orlando. I take care of my mother as a caregiver, so I need to be able to get out.
Sir, you need do you want to get out on ROR? Is that what you're asking? Your Honor, would you consider release my client on ROR, Your Honor?
Due to the fact that I am a caregiver for my mom, she's in stage 4 cancer. I just came here to chaperone my nephew at the classes. I never knew that I had no license, and I had my regular license. He took it.
Now we're getting into the facts. I don't know if you want to do that.
All right, I just want to be able to take care of my mom. She's on bed rest. I need to help be there for her.
For the record, state would object. He is a multi-state offender out of California, Ohio, and Texas. He currently has warrants out of Ohio and Alabama, and he has 7 failures to appear that we know of, the last being several months ago.
Yeah, I can't do anything for you today, sir. You do have a chance to have a bond hearing in front of the trial court, okay?
They won't let me bond. I tried. You know?
Today's just probable cause. You can have a bond hearing in front of the trial judge that's assigned to the case, okay? All right, good afternoon, sir. Tell me your name.
Yes, ma'am. Yes, Your Honor. My name is Eric Barnes.
Eric Bonds? Barnes.
Yes, ma'am.
If you're eligible, sir, you're eligible.
Okay, you're here today for first appearance. You have 3 charges. The first is tampering with physical evidence. The second is possession of drug paraphernalia. And the third is resisting an officer without violence. I do find probable cause for those charges, and I'll appoint the public defender to represent you. On count 1, I'll set your bond at $1,500. And on counts 2 and 3, your bonds will be stayed at $500 on each count, okay?
Ma'am, I do not have any funds at all. I don't have nobody to bum me out or anything. I really don't. God knows it. In Jesus' name, could I please get out?
I understand today's just probable cause and your initial bond determination. I actually set your bond at lower than the standard amount, which should be at least $2,500. I set it at $1,500. You do have an opportunity to have another bond hearing in front of the trial judge. I would encourage you to seek some drug treatment while you're here at the jail if you're not able to bond out. They do have a lot of really good programs here at this jail, okay?
They was wrong about the drug stuff.
Okay, well, don't talk about the case right now. All right. Stay in contact with the public defender if you get out.
You just set him up on, right?
Yeah. All right, good afternoon. Tell me your name, please.
Antonio Bell.
All right, you're here today for first appearance. You're charged with grand theft, 3rd degree of a firearm. Can I have the attorney's approach? All right, sir. I do take possession of firearm cases very seriously. However, in this case, in light of the facts in this particular situation, I'm going to, I do find probable cause. However, I'm going to give you a lower bond than is currently set. It's currently set at $5,000. I'm going to reduce that to $1,000, but you're not to possess any firearms or weapons while you're out on bond. If you own any firearms, you need to surrender them to law enforcement, okay, within 24 hours. Also, I did appoint the public defender, so you need to stay in contact with them, okay? It's not gonna, I don't know if he's gonna be your specific public defender, but the office is appointed. So reach out to their office within a week of you being released.
I'm from Jacksonville, so I don't kind of know like where to go or who.
You don't have to go anywhere. They have a website, they also have a phone number, okay? And they should get their contact information, just stay in contact with them.
What's up?
And the next defendant qualifies for PTR.
Okay, tell me your name, please.
Juwan Brown.
All right, sir, you're here today for initial appearance. You do qualify for I do find probable cause for the offense. You do qualify for pretrial, I'll appoint the public defender. Do you want pretrial release or the monetary bond?
The bond.
The bond schedule is 5,000.
Okay, it'd be a $5,000 bond.
Yes, ma'am.
What? Yes, what?
Yes, Your Honor.
Which one? You want the bond or pretrial release?
The bond.
Okay, so your bond will be $5,000. You're not to possess any weapons or firearms, okay? If you have any of them in your possession, you need to surrender to law enforcement within 24 hours of you getting out, okay?
Yes, ma'am.
All right. Stay in contact with the public defender.
You gotta call someone to bond you out. You know that, right?
All right, good afternoon. Tell me your name, please.
Come on, check on.
And he qualifies for PTR.
Did you say the right name? All right, sir, I do find probable cause for the charges. You're here on 6 counts. You have racing, possession of marijuana, driving while license suspended, possession of drug equipment, obstructing justice, and reckless driving. You do qualify for pretrial release. Did you want to accept that?
No.
No? Okay. Then the bond on count 1 will be stayed at 1,000, count 2 will be stayed at 1,000, count 3 will be stayed at 500, count 4 will be stayed at 500. I'm sorry, 1,000. On count 5, is that an F3?
It's an F3 without force, so schedule's 25.
Okay, so your bond will be set at 2,500 on count 5, and count 6 will be stayed at count 6 will be stayed at 500. Do not possess any weapons or firearms if you get out. All right, good afternoon. Tell me your name, please.
Carrie Grayson.
All right, you're here today for first appearance. You have a failure to appear in a possession of oxycodone case and then a possession of drug paraphernalia. The judge who signed the capias has stated that there's to be no bond. I'm showing that you do not qualify for the public defender. Do you make $1,000 a week?
She just asked me how much I make monthly. I don't know if she did that correctly.
Okay, how much do you make per month?
It's not really like stable income because I'm self-employed, so maybe the highest sometimes is 2,000.
Okay, so can you afford to hire your own attorney?
No, ma'am.
Oh, okay. So actually, you already have a public defender, is that correct?
You guys never gave me a public defender.
Okay, I'm going to appoint the public defender to represent you unless they've already been appointed. You have no bond right now, so they'll probably come to see you in the jail, but if you bond out at a later date, make sure you stay in contact with them, okay? All right, good afternoon. Tell me your name, please.
Marshall Gwynn.
All right, so you're here today for first appearance. You're charged with aggravated assault with a deadly weapon without intent to kill. I do find probable cause for that offense, and I will appoint the public defender to represent you. Does state wish to be heard on bond?
Yes, Your Honor, and as charged as an F3 with use of violence or force, the schedule is 5,000. We would be asking for 5 with standard conditions. I do believe it was a road rage type incident, so we'd be asking for 5 in standard conditions.
Your Honor, we would just like the court to acknowledge the fact that he has no history to speak of. We know the court has discretion. The schedule is 5,000. We would ask for a lower amount that the court finds appropriate.
When I read the police report, I was initially going to set a higher bond. However, based on the fact that you don't have criminal history, I will follow the bond schedule in this case and set the bond at $5,000. You're not to be in possession of any dangerous weapons or firearms while you're out on bond, and you need to stay in contact with the public defender's office, okay? No contact with any of the alleged victims in this case.
Thank you, Your Honor.
Harold?
Harold?
Outside medical.
Outside medical?
We'd ask to waive that appearance, Your Honor.
Oh, and his bond is pending. It looks like his bond's pending, just.
Okay, well, just in case, I do find probable cause for the charges, and I'll leave the bonds as set.
Are we going to be appointed, Your Honor?
Oh, I'll appoint the public defender.
I didn't know if there was a situation where we wouldn't be. Okay, thank you.
Okay, good afternoon. Tell me your name, please.
Travis LeVar Jackson.
All right, so you're here today for first appearance. You were arrested for possession of a firearm while in commission of a felony and driving while license suspended. I will appoint the public defender to represent you. Does the state wish to be heard as bond as to count 1? Is count 2 charged as a felony?
No, I believe it's charged as a misdemeanor. Let me double check.
Oh, he's got 3 priors.
He's got priors, but I believe he's also out on, oh, it is charged as felony. Hold on, give me one.
Your Honor, from my reading of it on the affidavit, because of the past counts that are referenced, it was elevated to a felony. But if I'm incorrect, Your Honor, and it's actually a misdemeanor, then I don't believe there would be probable cause for the possession of firearm commission of a felony.
And it is a felony, Your Honor, due to him, the prior refusal of a DUI. He is currently also out on bond out of Volusia for a DUI. That's what enhanced it to a felony. So count 2 is an F3. We'd ask that you stay the 2,500. Count 1 is an F2. Despite it being an F2, there's no use of force, so we'd ask for 5,000, which is in keeping with the possession of a firearm charge, given that he is currently out on bond for DUI and reckless.
Okay, sir, I do find probable cause for counts 1 and counts 2. I'll appoint the public defender to represent you on those cases. On count 1, I'll set bond at $5,000, and on count 2, I'll stay your bond at $2,500, okay? Make sure you're not driving unless you have a valid license, and you're not to possess any weapons or firearms while you're out on bond for these offenses, okay?
Yes, ma'am.
If you do bond out, stay in touch with your public defender. Hello. Tell me your name, please.
Jalen King. Good afternoon, Judge.
Good afternoon. Okay, sir, you're here today for first appearance. You were arrested for a grand theft motor vehicle. I do find probable cause for that offense, and I'll appoint the public defender to represent you. Your bond in that case will be stayed at $2,500. You were also out on bond for a burglary of an occupied dwelling case. Does the state wish to be heard?
Yes, Your Honor, that out-on-bond case, the 9434 case, information has been filed. We filed 3 counts, a burg occupied dwelling, false imprisonment, and resisting without. Given that it is filed and a theft-related offense, and he picked up a new theft-related offense and crime of dishonesty, state is requesting that you revoke.
Judge, it's my grandmother's house.
Okay.
Partially taking into account that he does have 13 prior failures to appear, and several VOPs and other indications of his unwillingness to comply with court orders. So state would request that you revoke, ensure of any conditions you can place to ensure compliance.
Your Honor, there's the out on bond, Your Honor, the out on bond charges, I believe that would, if you were to revoke and double, that would be a fairly hefty bond. I believe that would be enough to secure his person and to ensure that he wouldn't do anything or wouldn't pick up any arrests going forward, Your Honor. We ask that you at least revoke and double and give him the option of paying that bond and proving to the court.
Judge, may I please say one thing on my behalf, please?
No, it's
a reference to the court.
not at this point in time. It's, you know, I'm,
Please, Judge.
on the out on bond, I am going to revoke his bond. Burglary of an occupied dwelling is a serious offense. You can take it up with the trial judge, but I'm going to revoke the bond on that case. And I believe I already said I would stay the bond at $2,500 on the other count.
Please let me tell you, Judge, please. My case with my false, yes, sir. Judge, please, Judge, may I please?
There's nothing you can say today to change my mind. It's best if you don't say anything about the case, okay?
Told you nothing you say will change your mind, but you know what? If you say something, it can make your life harder down the road.
Yes,
so,
sir.
So you just gotta have faith in your attorney.
I do have faith in the judge.
Okay, good luck to you, sir. We'll have to do the next case now.
So can you tell me what you revoked my bond on? I'm not sure. Could you tell me what charges got revoked?
The burglary of a dwelling case. There's 3 counts. The false imprisonment, burglary of a dwelling, and resisting without.
So how do I get it back? Can you tell me?
Your public defender will come talk to you, okay?
And Your Honor, state had motion as to the 15380, requesting it be transferred to 12 without lower case number.
That will be granted. All right, good afternoon. Where are we at? Mac Leslie? Hi, good afternoon. Tell me your name, please.
Mac Leslie.
All right, you're here today for first appearance. You're charged with driving while license revoked as your third or subsequent offense. I do find probable cause, and I'll appoint the public defender to represent you. Your bond will be stayed at $2,500. If you bond out, make sure to stay in contact with the public defender's office and do not drive unless you have a valid license.
That way, sir.
All right, good afternoon. Tell me your name, please.
Jamal McMahons.
Your Honor, I don't have a probable cause argument per se. I just wanted to get the court's opinion on this. This is something I should have asked the court, the state, but he's being charged with 2 resistings, and one was based on, and
Is this McMinn's?
McMinn's, yes, Your Honor.
Oh, okay, I was looking
I
at.
can give you a moment to put his name on the record, Your Honor. I apologize. I just wanted.
He did, I just want to make sure I heard him correctly. Okay, so the resisting without violence, you wanted to be heard?
Yeah, just briefly, Your Honor. It just, one of them was based off of maybe, from what it sounds like in the affidavit, evasive behavior as it pertains to giving out his name. I don't know if that would qualify as resisting. Intuitively, I don't feel like it does, Your Honor. So we would just ask the court to consider maybe not finding PC on that one. Because he's being charged with.
Well, the issue, is I do believe it's enough for resisting. I'm willing to lower his bond, but the problem with him is he's got a failure to appear on a grand theft case, and he's got no bond on that case. Is that accurate?
Yes, Your Honor. He has no bond on that failure to appear. We'd ask that it remain at no bond. Regarding the resisting without, so I would argue that there is probable cause. It is stated within the statute that that's enough for probable cause. For a resisting, I believe the bigger issue is, so I would argue that there's probable cause on both. However, we cannot charge both based on it being from one incident. So we would ask that you stay the bond on one and ROR the other.
Okay. I'm happy to do that. So on count 1, his bond will be stayed at 1,000, and I'll release him on his own recognizance as to count 2. And well, I found PC on both, because technically refusing to give your name at that point is resisting, but with what she said, I'll still ROR him.
I understand.
But, you know, his bigger issue is the failure to appear, and that case was issued by a different judge who put no bond. So I'm not going to touch that one right now.
With that in mind, Your Honor, seeing as he's effectively going to be held no bond for the time being, would you consider, Your Honor, not taking any action on the driving while license suspended? It's from 2023. Obviously, it's been filed due to the fact that it's a citation, but it's pretty dated, Your Honor. It goes back to February 25th, 2023, and he's being held on the on the habeas. We ask that you just take no action for now.
And I believe that was entered in error. That case is closed.
Oh, it's closed?
Yeah, that case is closed. So
Which one's closed?
They had an out on bond for Willis, but that case is closed. It shouldn't have been.
Okay.
It shouldn't have been a first appearance detainer.
It's been closed since May.
But the grand theft is still pending?
Yes.
Right?
Yeah,
Okay.
yes.
All right. Okay, good luck to you, sir.
And the next defendant qualifies for PTR.
All right, tell me your name, sir.
Jalen Maranta?
Maranta?
Yes, ma'am.
Is that you? Okay. All right, sir, you're here today for first appearance. You were arrested for possession of a firearm by convicted felon and possession of cannabis greater than 20 grams with a weapon. I do find probable cause for those 2 offenses, and I'll appoint the public defender to represent you.
Oh, I apologize. You found probable cause, Your Honor? Because if you didn't, and I just saw no reference to him being a convicted felon on.
Your Honor, it's within the affidavit. It says a criminal history check indicated Jalen Maranta is a convicted felon.
It's like the 3rd line from the bottom.
Okay, just confirming, Your Honor.
Is that a F3 or F2?
The possession of firearm by convicted felons in F2.
Okay, so on count 1, your bond's going to be set at $5,000, and on count 2, your bond will be set at $2,500. If you do bond out, make sure, I am appointing the public defender, so make sure you stay in contact with them. You're not to possess any weapons or firearms, okay?
Yes, ma'am.
If you end up with any in your possession, they need to be turned over to law enforcement within 24 hours, okay?
Yes, ma'am.
All right, good afternoon. Tell me your name, please.
Michael Murillo.
All right, sir, you're here today for first appearance. You're arrested for possession of cocaine. I do find probable cause on that case, and I'll appoint the public defender to represent you. You also have an open container violation. I'll appoint the public defender to represent you on that case. I find probable cause for that. Your bond will be stated at $250 on the open container, and then it'll be stated $2,500 on count 1. If for some reason you're not able to bond out, I do encourage you to take advantage of some of the programs that the jail has to offer here, okay?
Your Honor, yeah, Your Honor, I don't necessarily know how it's going to work downtown, but is there, I don't believe at this stage there would be any sort of, because I know there's mental health PTR, is there anything associated with substance abuse that the court has available to it? I don't know.
Is there what?
Anything pertaining to substance abuse treatment?
He could try to get into drug court. I don't know if he's going to qualify, but, so you'll have a public defender that's going to come out and see you, but you might want to ask them if you qualify. I don't know if I can do the referral today. It's a little too soon. We're just at the probable cause stage, but you might want to look into drug court. But I was saying if you get into a program here, maybe that'll get you a jump start into things, okay? All right, good luck to you, sir. All right. Good afternoon. Tell me your name, please. Mr. Pilgrim? Okay. All right, sir, you're here today for a first appearance. You were arrested for possession of cocaine with intent to sell or deliver, and possession of methamphetamine with intent to sell or deliver. I do find probable cause for those charges. Those are F2s, correct? Or no?
Yes, Your Honor. The schedule is usually about 15. However, most of the judges, depending on history, will reduce to 75. Your Honor, state would argue that, would ask for 75 on each count, arguing partially that a little over $2,000 was also found on his person.
Okay, sir, I do find probable cause, and I'm going to set bond at $7,500 on count 1 and $7,500 on count 2. Does the state wish to be heard on the out on bond?
Yes, Your Honor, and an information was filed on that case, the 25 CF 9158. We filed 1 count of possession of firearm by convicted felon. Given that it is filed, state's requesting that you revoke. Mr. Pilgrim's history seems to be largely the similar things as drug offenses and firearm offenses. So we are requesting that you revoke that out on bond case.
Your Honor, we would ask that the court consider revoking and doubling his bond instead.
So, Mr. Pilgrim, I'm not going to, I'm going to revoke your bond on the out on bond case, which is 2025 CF 9158AO. Just the fact the charges are too similar. I am appointing the public defender to represent you. So for some reason, if you do bond out, or if you get a bond on the other case, make sure to stay in contact with the public defender's office, okay? I'm not sure that matters in this situation. All right.
And then state does have motion as to the 15373.
Okay, that will be granted. All right, good afternoon. Tell me your name, please. All right, sir, you're here today for first appearance. I reviewed the charging affidavit, and I do find probable cause. The state wish to be heard as to bond?
Your Honor, state will leave within your discretion.
F2 or?
I believe it's an
F3.
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 Usually it's about 25 is what's standard.
All right, I'm going to set bond at $2,500. I am appointing the public defender, so make sure you stay in contact with them. Make sure you comply with all requirements that were initially in place if you do bond out, okay? Do not possess any weapons or firearms. All right, good afternoon. Tell me your name, please.
Anderson Urena.
Last name?
Urena.
And he does qualify for PTR.
Okay, sir, you're here today for first appearance. You were arrested for a charge of petty theft and possession of an anti-shoplifting device. Your bond on count 1 is set at $500, and on count 2, it's set at $2,500. You qualify for pretrial release. If you do that, you would have to report to your pretrial release officer. Do you want pretrial release? Okay, so you'll be released on pretrial release. I am appointing a public defender to represent you, so make sure you stay in contact with them, okay? Are they gonna, does he get an arraignment date or no? Okay. I don't have a court date for you right now, but that's why you need to stay in contact with them, okay? Do not return to the scene. No return to the scene of where this allegedly occurred. Okay?
Thank you so much.
I'll let you out, sir. Yeah, you're done. I'll let you out.
Good afternoon. Tell me your name.
Joe. It's Joe Williams.
What's your last name?
Williams, ma'am.
Okay, what happened to Wilkerson? Okay, 250-37227.
They bonded.
Okay. All right, Mr. Williams. You're here today for first appearance. You were arrested for possession of cocaine, possession of cannabis, less than 20 grams, and resisting an officer without violence. I do find probable cause for those offenses, and I'll appoint the public defender to represent you. Your bond on count 1 is set at $2,500. On count 2, it's set at $500. On count 3, I'll reduce it to $500. If you do bond out, make sure you stay in contact with the public defender, okay?
Ma'am.
All right.
He has an open case, Your Honor.
What?
He has an open case out on ROR.
You're also out on bond in a possession of MDMA case.
And Your Honor, that case was from September. He was ROR'd on a 33-day motion, October 13th. The original bond on that case was $2,500. Given that it is so close in time and it is still with FDLE, we are requesting that you revoke and double and set it at $5,000.
Your Honor, I don't believe that case has been filed on. I think it stems back to September. We would just ask that, at this moment that you take no action on it.
If he was ROR'd, how did he have a $2,500 bond?
It was $2,500 and then he ROR'd on a 33-day motion. So we're asking that you revoke the ROR and double the original bond.
We were just like that. It hasn't been. I know he's been released. He ROR'd, I believe October, but it hasn't been filed on. And it stems back to September.
Sir, do you have a job?
I had one, then I lost it when I got in trouble.
Okay. I'll set a bond of $1,500 on that case. You really need to get some treatment.
I know I
Okay, if you can't afford to bond out on these cases, I would encourage you to get treatment in the jail. There's some really good programs here, okay?
Yes, ma'am.
And state has a motion as to the 15377, requesting it be transferred to 17, that lowercase number?
Okay, the motion to transfer is granted. All right, good afternoon. Tell me your name, please.
So my name is John Young.
Okay, sir, you're here today for initial appearance. Okay, you were arrested for DUI a fourth or subsequent offense, a DUI refusal, and, I'm sorry, driving while license suspended, and then a DUI, yes, count 3 is the DUI refusal. I do find probable cause for all 3 offenses, and I'll appoint the public defender to represent you on those cases. Your bond will be stayed at $5,000 on count 1, $5,000 on count 2, and $5,000 on count 3. If you do bond out, you are not to drive unless you have a valid license. I'm also going to order that you not use alcohol to the point of intoxication.
Yes, ma'am. May I say something real quick, please?
I would not advise it because I'm.
Sure.
Sir, I'm not familiar with the bond process, Your Honor, but I guess my client has a request as to the bond.
My dog is in the house. I'm from Jacksonville. I tried to get out here in Orange County here, and they told me that I would have to get my bondsman out of Jacksonville. I got a bondsman out of Jacksonville. Only thing is, the bondsman out of Jacksonville said I have to have the $15,000. I have to have collateral. So I'm telling him about my dog in the house. My dog would be dead.
Sir, I would encourage you to call animal control or a neighbor because they can go take care of the dog.
Okay, so I don't have that collateral. So that leaves me back to square one. If you will set me a cash bond, I got $1,000. If you will combine the 3 and I paid $1,000, I got it in my wallet right now. I mean, I don't have $15,000.
Okay.
Ma'am, I'm so sorry, but I don't have $15,000.
We're done. Okay, we'll be in recess until tomorrow.
Say his name and say his name and